Human Rights Division of the High Court in Accra has dismissed a judicial review application filed by suspended Chief Justice Gertrude Torkornoo, describing it as an abuse of court process and stating that the court lacked the jurisdiction to hear that. The ruling delivered by Justice Kwame Amwako represents the second major legal setback for Justice Torkornoo in her efforts to stop impeachment process initiated under Article 146 of the 1992 Constitution. The suspended Chief Justice had filed the judicial review on June 9, 2025, seeking 9 reliefs. Among them were declaration that the Article 146 investigative committee had acted unlawfully and a request for the court to halt its proceedings until she was provided with authenticated copies of petitions and responses. This followed a failed injunction application to continue with its work without those authenticated documents. Number 3 claims that the committee was wrongfully conducting adversarial proceedings rather than impartial inquiry. Number 4, allegations that the committee's composition was unlawful. Justice Samako held that litigating these issues at a high court while they are under active consideration by the Supreme Court amounted to duplicative litigation and an abuse of the court process. So the reliefs dismissed for want of jurisdiction. The remaining reliefs were struck out of jurisdictional grounds. This includes 1 request to nullify the committee setting on the basis that the Chief Justice was denied a fair hearing. That's number 1. Number 2, allegations that her legal team was prevented from representing her during the proceedings. Number 3, claims of procedural breaches of the Constitution and the High Court into bracket civil procedure rules. Number 4, an application for an order of certiorari to quash the committee's proceedings. The court held that it could not inquire into these matters as they related directly to proceedings of the Article 146 committee, which under 146 clause 8 of the Constitution are to be held in camera and shielded from external review. So these are the reasoning for the dismissal of the case. We'll go on the phone line shortly and speak to constitutional lawyer Paul Kumi. But still in the court, the High Court in Accra has dismissed an application filed by the former Finance Minister, Mr. Ken Ofori-Atta, seeking to strike out an arrest warrant issued by the Office of the Special Prosecutor. In a ruling delivered yesterday, the court upheld the validity of the warrant, stating that the application by Mr. Ofori-Atta lacked merit and did not provide sufficient legal grounds to nullify the directive of the Office of the Special Prosecutor. Mr. Ofori-Atta, who was being under investigation by the Special Prosecutor over alleged procurement breaches and potential corruption related to certain financial transactions during his tenure, filed the application to challenge what his lawyers described as an unlawful and procedural flawed warrant. However, the court disagreed with that section, ruling that the Office of the Special Prosecutor had acted within its legal mandate under the Office of the Special Prosecutor Act 2017 at 959. The judge further noted that the former minister had the opportunity to respond to the allegations through due process rather than seeking to invalidate the warrant outright. So, what does it mean legally when a court says it lacks jurisdiction in a matter like this?
Yes, so every court has what it's called its power, a mandate to handle a particular matter. So where you bring a matter before the court and the court thinks that what you are asking the court to do, it does not have that mandate to do it, then it will tell you that it has what they call lack of jurisdiction. Indeed, or it is saying that it doesn't have the legal authority to hear that particular case or make a decision about it. That is what a court, when it says it lacks jurisdiction, wants to put across.
I see. Now, what might the Human Rights Court consider this judicial review application an abuse of court process?
Yeah, so an abuse of court is where you are bringing before the court a particular issue which is either pending before another court or that particular matter has been determined by another court. I hope you understand what I'm saying.
Very well.
Now, in the case of the Chief Justice, there had been something that she has brought before the Supreme Court, and that case is still pending. So, to the extent that that particular matter is pending before the court, the Supreme Court, you cannot bring that same matter, to that court, because then the court is of the view that you are making improper use of the legal proceedings. So you are either using the system to harass or delay or obstruct justice. So here you are with issues that the Chief Justice wanted the High Court to make a determination in respect of. Meanwhile, those issues are substantive issues before the Supreme Court. So what is it that you want What is it that you want the High Court to do? I hope you understand what I'm saying.
Very well.
So, in certain cases, those actions will be described as being frivolous and vexatious and deliberately close to create some unfair injustice or prejudice in the minds of people, and in a way to also destroy or disturb the cause of justice.
Now, given that the impeachment process is being carried out under Article 146,
yes,
does the Constitution allow for judicial intervention at all during such proceedings?
No. So that was why the court said it lacked jurisdiction.
Okay.
Because all those activities are to be done in camera. And so the court is of the view that to the extent that the Constitution is clear that all these things are to be done behind closed doors. So how can the court make a determination? Because these are things that are supposed not to come out. So why are you bringing out something that is not supposed to come out for me to make a determination on? I hope you understand me.
Yeah.
And that is why the court is saying it lacks jurisdiction. Because the court is saying specifically that the Constitution says all issues about the removal of the Chief Justice must be done, in camera. That is to say, those issues should not come out openly to the hearing of anybody. I hope you get to me.
Sure.
So if you are now asking me as a court to get into that matter, the Constitution even stops any other person, apart from persons involved, to know about it. So how can the court, enter that particular fray and make a determination in respect of that particular matter, which is supposed not to be known by any other person?
Yeah. I see. So could Justice Torkornoo have filed her case in a different court with appropriate jurisdiction?
Yes. So what he had done was the one she did at the Supreme Court. Right? So those are the ones that her lawyers must be pursuing. This whole business of going to the Human Rights Court, going to the ECOWAS Court, I will be honest with you, it is an exercise in futility. I think that she will have to abide by the timetable of the Supreme Court, get her hearing over there.
Okay.
And indeed, I have discussed with colleagues. Now look, why doesn't the Chief Justice keep quiet, go through all the processes that she's supposed to go through, let the verdict come, and where the verdict goes against her, then she can institute an action. I hope you understand what I'm saying.
Yeah.
Because in our Constitution, there's no work which says that when the President removes the Chief Justice cannot petition or cannot go to court against the said remover. There's no work in the Constitution.
Okay.
But now the Chief Justice is asking that hearing, which ought to have been done in private, that is behind behind closed doors or in camera, Now a whole Chief Justice is saying, no, forget about what has been provided for in the Constitution and come and do the thing in the open. Will that not be flouting the provisions of the Constitution? So I am of the view, and that's my respected view, that she should wait, go through all the things that she's supposed to do, right? And then when things don't go the way she wants, then she can take a legal action and then seek the release. In spite of the fact that, look, they were supposed to have done this, they didn't do it. My lawyers raised those issues, but they were ignored. They were supposed to have also provided us with this. My lawyers raised that issue, but they were ignored because all those things will be recorded. I hope you understand what I'm saying. Because by which time there will have been the determination of the matter. So even there, the court can say, yes, you did this thing in camera, but now that you are finished and you have made a determination, and this woman is saying that the determination was wrongfully arrived at, then the court can make an order to ask for the said proceedings to be made available and for the court to be able to establish whether or not the Chief Justice was giving a fair hearing. But now that these issues are going on, she's, attacking the membership of the 2 justices. She's also attacking the membership of the 3 other laymen. She's talking about the fact that she doesn't even know the issues that has brought her before the committee. Then one will ask himself or herself, what was it that she gave responses to after the president had sent those things to him? So unless at the hearing there is a clear case that the documents that were given to her as being the petition, questions and issues that are being raised at the hearing are completely different from the petition that was given to her and for her to respond to. I hope you understand.
Sure.
So those are the things that she could take her time, wait for the full or the final determination of the matter, and then she can take it up. But this whole business of going to the ECOWAS court, talking about her rights being infringed and asking for $10 million, when you do these things, you begin to get under the skin of the populace.
Sure.
And even where you have the earlier sympathy of people, these acts will begin to let people begin to, abandon you.
I see. Now, finally, before you go, does the rejection of this judicial review weakens her pending constitutional interpretation case at the Supreme Court?
Not at all. Not at all. Not at all. I mean, these are issues that were brought before the... when it comes to the issue of certiorari, certiorari is not talking about the correctness or otherwise of a particular issue. Certiorari is talking about procedure, right? So once a particular procedure is not followed, because there are rules and regulations. So we have rules of court. So there are certain procedures that must be followed. Once the one who sends the matter to the court says that I want certiorari because certain processes were not duly followed, that, if it is proved before the court, is enough for the matter to be struck out. So in this particular one, all she is saying is that certain procedures were not followed and a whole lot of things were not properly done. Now the court is saying that part of her relief that she was seeking amounts to abuse of court processes, and then the other ones also, the court is saying it doesn't have jurisdiction in respect of them. So they do not in any way harm a case at all. If she has a good case before the committee which is investigating her matter, it is not going to affect it at all. So whether she is flopped 10 times at the various courts, it is the issue before the committee as set up under the Constitution, Article 140, which will determine whether she remains at post or not. All other issues are tangential. They do not go to the core of the matter before the committee.
Interesting. Well, let me have your quick reaction on still on court matters. The Accra High Court dismissing application filed by former Finance Minister Ken Ofori-Atta The court says that the court upheld the validity of the warrant, stating that the application by Mr. Frater lacked merit and did not provide sufficient legal grounds to nullify the directive by the OSP. Let me have your quick reaction on that, sir.
Yes, so this was an application which was put before the High Court by the lawyers of Ufuriata, of course, at Ufuriata's instruction. And the court is of the view that regarding the processes that were followed by the special prosecutor or the office of the special prosecutor, everything was done according to law. And to that extent, the application to have those processes set aside for him being declared wanted person to also struck out. The court didn't find any merit in that, and that's the reason for which the court struck out and distributed that application.
So Mr. Ken Frater can be brought into the country to face justice, I guess.
Yeah, so what is happening is that he has been declared wanted. If he comes to the country on his own, he can go straight to the office of the special prosecutor, say that you guys were looking for me. I was not available at the time you were looking for me. I have now come.
Okay.
When he goes there in that manner, obviously he will be received by the office of the special prosecutor. They will have some few chats with him, and where all things show that he is somebody who is not a flat risk, they will admit him to bail, and then as and when they need him, they will bring him. I mean, they will invite him to come.
Okay.
But if he doesn't do that, and he is arrested under the instructions of Interpol, and he's brought to Ghana, then that will be a different scenario. Because in that case, the special prosecutor can say that he will be a flat risk if he is granted bail. So you may end up being himself whilst the case is determined at the court. So if you should ask me the best option for Furiata, all he needs to do is this: he should come down into Ghana himself, not under the how do you call it? Not under the Interpol arrest. He should come and then go and report to the office of the special prosecutor. They will have some few discussions, and I'm sure that he could be admitted to bail. Yes, that is a possible thing.
Right. Counsel, thank you so much for your time as always for speaking with us. So that constitutional lawyer Paul Kumi there. So I'll tell you about a